So I don't think it's a hot take to say that every company that sells some kind of product needs a proper refund policy. People are spending their hard-earned money, and they need some assurance that if something they buy is defective or isn't as advertised, they have some leeway to return the product and get their money back. Unfortunately, certain companies have not been particularly good at that, and among those who've been criticized is Sony, particularly by the Australian Competition and Consumer Commission. Back in May 29th of 2019, the organization released the following post in which they talked about customers complaining about how PlayStation refused to give people refund despite Australian laws that protect consumers and ensure that they have to have a certain time frame where they can decide whether they want to return a product and get their money back or not. And the deliberation has been reached today on June 5th, 2020, and Sony is now forced to pay $3.5 million in penalty for misrepresenting PlayStation gamers' rights. Now, I surmise that this is maybe Australian dollars that they're talking about here. So if we convert that to US dollars, we're talking about $2.4 million. And here is what this article has to say about why they reached this deliberation. Quote, the federal court has ordered Sony Interactive Entertainment Network Europe Limited, Sony Europe, to pay $3.5 million in penalties for making false and misleading representations on its website and in dealings with Australian consumers about their Australian consumer law rights. Sony Europe made misleading representations to 4 consumers who believed they had purchased faulty PlayStation games. This occurred when Sony's customer service representatives told them over the phone Sony Europe was not required to refund the game once it had been downloaded or if 14 days had passed since it was purchased. And here's a quote from ACCC Chair Rod Sims. Consumer guarantee rights do not expire after a digital product has been downloaded and certainly do not disappear after 14 days or any other arbitrary date claimed by a game store or developer. In other words, the company does not get to suddenly make up a law about how, well, you downloaded the game digitally, the product was delivered digitally, therefore you forfeit any sort of privilege or right to get a refund. Like, that's Sony's policy, but that doesn't coincide with Australian consumer laws, and that's where the issue lies. The post continues, the court also declared Sony Europe breached the ACL by telling one of the 4 consumers it did not have to provide a refund unless the game developer authorized it, and by telling a 5th consumer that Sony Europe could provide a refund using virtual PlayStation currency instead of money. So this is all flat out BS under the Australian consumer laws, and this is something that is being called out by this organization, the Australian Competition and Consumer Commission. To that effect, Mr. Sims said what Sony told these consumers was false and does not reflect the consumer guarantee rights afforded to Australian consumers under the Australian consumer law. Consumers can obtain a repair, replacement, or refund directly for products with a major fault from sellers and cannot simply be sent to a product developer. Refunds under the consumer guarantees must also be given in cash or money transfer if the consumer originally paid in one of those ways, unless the consumer chooses to receive store credit. So this has to be an option. They can't force people to get refunded with PlayStation credit. The customer has to be able to choose whether they want a refund in the original payment method or via the credits. The post then adds, between October 2017 and May 2019, Sony Europe's terms of service implied that users did not have consumer guarantee rights regarding the quality, functionality, completeness, accuracy, or performance of their purchased digital games. This was false, as these guarantees cannot be excluded, restricted, or modified, or at the very least under Australia's customer laws. If you're going to sell your products in Australia, you have to abide by the consumer protection regulations that have been put in place. You cannot just make up your own rules and talk about how digital purchases relinquish your right for refund because you say so. Mr. Sims adds, consumers who buy digital products online have exactly the same rights as they would if they made the purchase at a physical store, no matter where in the world a company has its headquarters. If it is selling to Australian consumers, the Australian consumer law applies Damn right. Sony Europe admitted liability and made joint submissions to the federal court with the ACCC. Sony Europe will also contribute to the ACCC's legal costs. This aspect of Australia's consumer laws is something that I've always appreciated. Recall that not that long ago, they forced Bethesda to issue refunds on Fallout 76 when they refused to do so after customers discovered that the game was falsely marketed, that it launched broken and unpolished, and that it just wasn't what was advertised. But Bethesda, they made up their own policies about how, well, you've already downloaded the game and purchased it or played it a certain amount of hours, while at that point you are not eligible to get refunds. But in Australia, the same organization flat out said, no, that's not how things work here in Australia. You will issue refunds to your customers. And in fact, right here is the article pertaining to that situation from Games Industry. On November 1st, 2019, the news outlet published an article with the headline, ZeniMax to offer refunds for faulty Fallout 76 in Australia. And beyond that, more recently, on June 1st, 2020, EB Games will be offering refunds for Fallout 76 for people who purchased the game via that particular storefront and retailer. They are forced to give money back to people who felt slighted and cheated by this game. And yeah, suffice to say that plenty of people felt cheated by 16 times the detail, among many other promises. I honestly wish that more countries around the world would employ consumer protection regulations and refund laws akin to what Australia is doing here, and that these organizations would hold game companies accountable when they have really crappy refund policies in place. I've previously expressed my qualms against the Bethesda launcher's refund policy that basically stipulates that if you make a digital purchase, Bethesda is not obligated to give you any kind of refund whatsoever. If you made that purchase is final. Same thing goes for Nintendo, where they don't even allow you to cancel pre-orders made on the eShop, with their excuse being that the second you make that pre-order, the game starts preloading, and that means the game has technically been delivered to you digitally, it's been downloaded, ergo you just cannot cancel that pre-order, you have no leeway to get that money back. And that right there is obviously complete bullshit. Frankly, I don't know any other digital storefront that enacts such a strict policy where they restrict any ability to cancel pre-orders. But when it comes to refund post-launch, there has to be some kind of time frame that allows people to test out the product so they can determine whether this is a game that lives up to the marketing or whether it functions properly. And when it doesn't, people should have the right to say, hey, I want my money back. And I'm glad that Australia recognizes this and holds companies accountable when people speak up about cases where some kind of injustice was done as far as refunds go. But other countries, unfortunately, don't do it to this extent, at least as far as I know, at least when it comes to countries like the USA. I haven't seen the US force Bethesda to issue refunds for people who felt slighted and cheated by Fallout 76. This is a precedent that needs to be set worldwide, in my opinion, especially during an era when digital sales are on the rise while physical sales are becoming less and less popular. Now, Kotaku Australia actually provided additional details about the case, kind of getting into the nitty-gritty elements of how this deliberation was made. So it reads right here, the ACCC's case revolved around the experience of 5 users, nicknamed as follows, who were refused refunds by Sony support staff at different points in 2017. For 3 of the users, Sony submitted that even if a game had a major failure or some other failure to comply with a guarantee that could not be or had not been remedied, Sony support staff argued that they were not required to supply refunds if the game had been downloaded. In another instance, user CK was offered a refund, but only in the form of PSN wallet credit. None of this flies by under the Australian consumer laws. And then right here is an excerpt from Sony explaining why users could not receive refunds for digital purchases. The question reads, can I get a refund because I'm not happy with the quality of the game I purchased? The response reads, in this case, the content has been downloaded, is available to use on your console, and cannot be removed even after refunding. As the content cannot be returned, we cannot consider a refund of the purchase. As there is no actual fault with the content, we cannot consider consider a refund of the purchase. So that's a bullshit reasoning right there. It is up to the company to set up a system that allows people to return products, even if they are digital. Like if you want to return a physical product and a company tells you, oh, we didn't set up the proper infrastructure that allows us to take the product back and ship it to the supplier, like that just flat out wouldn't fly. It's on the company's responsibility to ensure that they're following the proper laws and that they set up the infrastructure that allows them to follow the refund regulations that are in place. It's not the customer's fault that Sony did not do that with how they set things up. And this goes true for any company that uses the excuse of, well, once a game is downloaded, it's downloaded, there's no way to give it back. You set up the system the way you did, and if you didn't think about how to handle refunds and returns digitally, that's on you, not on the customer. But the fact remains that the customer still needs to have refund leeway. There needs to be a refund period, a grace period that allows customers to make sure that the thing they bought lives up to marketing and isn't defective, as many AAA launches tend to be these days. Here's what he had to say. It is clear that Sony Interactive Entertainment Network Europe is a large enterprise with vast resources. Realistically speaking, a penalty in the sum of 3.5 million Australian dollars is highly unlikely to have a significant impact on SIENE's overall financial position, but that is not the point. The question is whether the size of the pecuniary penalty would operate as an effective deterrent. The penalty must be substantial in order to be meaningful given SIENE's resources, but must not be so high as to be oppressive. In my view, the amount of the proposed penalty is in each case sufficiently high to have a deterrent quality. Further, the penalties have been set at a level which acknowledges the factors which support a lower penalty that might otherwise be imposed. In particular, SIENE cooperated in resolving this proceeding. It has since amended the terms of service. It ceased to make the wallet statement on the confirmation of purchase page and changed the top-up confirmation email prior to the resolution of the proceeding, and it provided updated instruction to PlayStation Support Center staff. In other words, Justice Stewart is fully aware that $3.5 million isn't gonna rock Sony's world, that it's just a blip on the radar, but it is more of a warning shot, a slap on the wrist, to let them know that there are consequences to this, and that if they do this again, there might be, even bigger fines that they might have to face, something along those lines. But because Sony cooperated and changed their terms of service to match Australian consumer laws, the fines have been sort of reduced and mitigated to be more of that slap on the wrist rather than something that will cripple Sony in any way. It is substantial enough where they'll feel it, but not to the extent where it'll disrupt their operations to a great extent. And this is a warning not just to Sony, but to other companies as well. Justice Stewart added, I'm also satisfied that the penalty amounts proposed make it clear to other corporations dealing in digital goods that it is not acceptable to contravene the Australian consumer law. I consider they're of sufficient magnitude to deter others in the industry who may be disposed to engage in similar prohibited conduct. So it's a warning shot not just for Sony, but to anyone who wants to attempt to violate Australian consumer law by forgoing consumers' rights to refund in this country. So while 3.5 million Australian dollars is a drop in the bucket for a lot of these companies, it's enough that it'll get media attention. It's enough that word will spread. It's enough that it will send the warning that there are consequences to thinking that you can circumvent Australian consumer law. Now, I can only surmise that Sony made this change only for Australia, the only country that has castigated them for this trespass, whereas in other countries, it's going to be the same if you are dissatisfied with a digital product or find that it does not operate as marketed or that it's defective. If you downloaded the game and started playing it, Sony will most likely not issue a refund unless there's some huge media backlash against a specific product. Maybe then they'll consider it, but they're not obligated to give you a refund, which I think is bullshit. And not just for Sony, I'm talking about game companies just across the board who try to enact these refund policies that ultimately serve to prevent users from getting their money back if they are not happy with the performance and the quality of a product. Now, there are exceptions. I think the way Steam does it is really good, where they give you a certain time frame to test out the game for a certain amount of hours, and within that time frame you can choose to issue a refund or not. And then when it comes to companies like CD Projekt Red with GOG, their refund policy is by far the most generous. Some argue maybe too generous, given how much leeway it gives people when it comes to issuing refunds. Basically, they have, like a month? And they don't really take into consideration how many hours you played. CD Projekt Red believes that if there is consumer goodwill, if there is trust on both sides, very few people will take advantage of that generosity, that most people will be happy to contribute their money to a game that they genuinely enjoy and believe is properly marketed and lives up to a quality bar. So digital storefronts like Steam and GOG, and I believe Epic has pretty much the same refund policy as Steam. Companies like these have the right idea as far as refund policy is concerned, but there are also plenty of other companies like Sony and Nintendo and Bethesda and many others who could work to improve the refund policy so that it's generous and so that it's fair to customers who need some guarantee that they're able to return something that they're not happy with or something that doesn't work as intended. Or at least that's one man's take on refund policies. Let me know in the comments below what your thoughts and opinions are on Australia's deliberation and what your ideal refund policy would be. And to be further updated on all things gaming news, reviews, and discussions, stay tuned right here on Young Yeah. I'll see you guys next time. Young out.